Cyril Amarchand Mangaldas presents CNBC-TV18, The Thought League Season 3.
Hello and welcome to a brand new season of Cyril Amarchand Mangaldas presents CNBC-TV18, The Thought League, a platform where business leaders, legal minds, policymakers and global visionaries come together to ignite the next wave of transformation. This year is particularly special. It marks 10 years of Cyril Amarchand Mangaldas, a decade of redefining excellence, driving innovation and staying ahead of the curve. And what better way to begin this landmark season than with two of the most distinguished figures in the world of law and governance. Joining us today is none other than Honorable Justice D Y Chandrachud, former Chief Justice of India, a jurist whose visionary leadership continues to shape Indian law, society and constitutional thought. Known for his progressive judgments and deep commitment to constitutional values, Honorable Justice Chandrachud has been at the forefront of judicial reforms and technological innovation in the judiciary. We're also privileged to be joined by Cyril Shroff, managing partner of Cyril Amarchand Mangaldas, whose leadership and pioneering approach have helped redefine the future of legal profession in India. In this inaugural episode, we'll explore how the judiciary can empower India's journey to becoming at least a $30 trillion economy, but optimistically a $50 trillion economy by 2047. Gentlemen, thanks both of you for joining us here on the program. Justice Chandrachud, if we can start with you, sir. What can courts do? What can the judiciary do so that we are on track to, as I said, get to at least $30 trillion of GDP by 2047, which will require about 8% compounded growth? And of course, on the optimistic side, do double-digit growth, sir. Go on.
Business to flourish requires certainty in the legal system, in legal institutions. It requires the application of objective standards, and it requires efficient decision-making. The courts, in that sense, are the institution, particularly in a democracy, which hold this balance and ensure that in the process of governance, all stakeholders follow rules of the game which are clearly defined, where rights are preserved, and where there is efficient decision-making, efficient in terms of timeliness, in terms of outcomes. So courts are a vital stakeholder and a vital pillar in promoting, economic growth and ensuring development in a country like ours.
Mr. Shroff, opening thoughts, sir?
Absolutely. I sort of concur with what Justice Chandrachud has said. And I'd also like to add that it's not just the rule of law, but it's also the role of law as well. I think it's very important that rights are protected. I think private capital comes in and businesses thrive and infrastructure is built and a society takes foundation when rights are protected, whether they are constitutional rights or whether they are civil rights or corporate rights or private property rights. This is very fundamental to attract capital both from India as well as globally. In fact, in last year, the Nobel laureates in economics, Darren Acemoglu and Simon Johnson, won their prize for essentially expounding a theory that political governments which extend political liberties and property and protect property rights as broadly as possible are the ones that lead to stable economic growth. So protection of rights, and I think it's judiciary alone which can do that, is very fundamental to growth. And I personally also believe that the rule of law is a fundamental infrastructure of the country. We should not think of infrastructure only as roads, ports, airports, and things like that. That's the hard infrastructure. But the more important infrastructure is the legal infrastructure, and particularly the rule of law. And that is where I think the role of law plays a very important role in private capital formation. And we've seen that, even in how India's economic trajectory has been, that its private capital has formed when policies are clear, law is properly enforced, and the judiciary is working.
Justice Chandrachud, predictability is a big thing for private capital, for businesses. What can the judiciary do to sort of, ensure predictability for economic actors in the system?
For one thing, predictability really is something which is intrinsic to judicial functioning, because courts develop the law on the basis of precedent. They apply the law in incremental stages. So predictability of outcomes in that sense, if properly monitored by the judiciary, is something which is a natural consequence of the way courts and judges function. But predictability can be achieved by having domain experts who know what the area of dispute resolution is that they are resolving. So, for instance, if you have a dispute under the competition law, predictability will also be a function of having the right kind of person decide these cases. Or, for instance, arbitration law, or electricity law, or the insolvency and bankruptcy code. What has happened in India, especially after 1990s, and particularly in the last decade now, is that we have a whole host of laws which have been brought in the area of economic governance. And in order to ensure that we have predictability of decision making, we have to be very clear that the decision makers within the judiciary are A, properly trained, two, that they are able to understand the position of that particular case in the wider context of what's good for business and the nation. So at some point of time, the court must not only focus on the facts or the nitty-gritties of the case, but also the impact of that decision on the wider economic structure of the nation. And I think creating this sense of predictability is crucial because imagine a system which is uncertain. Why would someone come and invest capital if there is uncertainty about the fact that a dispute might go either way in a court? There has to be some degree of confidence that this particular legal system applies consistent yardsticks. These are settled principles of law. So though it might sound a little boring, frankly, that sense of boredom is key to predictability, of not doing something which is radical or excessively innovative, but developing over the building blocks which have been laid down for us in the past, and then adapting them to the needs of the modern economy.
Could you give us a sense for the uninitiated viewer, do we have sort of, in a way, business courts which look at businesses in particular? Do we have, domain expertise existing right now, or not really? And why has this not happened as of now?
Parliament enacted the Commercial Courts Act, and that was a welcome step, because the purpose of enacting the Commercial Courts Act was to create commercial courts and commercial divisions which would be equipped to deal with commercial disputes. Now, having said that, what has happened really is this, that because of the heavy burden on courts, you will have a court which deals with a multiple array of disputes. So very often, for instance, take the case of a high court. The same court may be called upon to decide disputes relating to service cases or criminal cases, or for that matter, then commercial cases. I think that is not good for the system. What we need to ensure and what we must do is to create this pool of people who are truly qualified and trained in that particular field of the law, because the law is becoming increasingly more specialized. Now, having said that, it's easier to postulate it than to achieve it, for the simple reason that there's a dearth of infrastructure. The judge to population ratio in India has to be substantially increased. But on an informal basis, at least, particularly in the commercial courts, there are courts in India like the Delhi High Court, the Bombay High Court, Bangalore, Kolkata, the Madras High Court, and a few other courts as well, which are dealing with the Gujarat High Court, which are dealing with a lot of commercial disputes. Now, within the court, there are obviously commercial specializations. And the Chief Justices, when they design the roster of work, bear this in mind so that cases of that particular genre should be assigned to judges who are truly qualified and have domain experience in resolving those cases.
Very helpful, Mr. Shroff. You represent some of the biggest corporations in the country, you and your firm. Give us your perspective on this issue, sir.
No, I agree with what Justice Chandrachud said that in theory it's a good idea about having specialized courts, and commercial court is one example. But the reality is that because of the sheer volume of cases and the burden on courts, that principle is not strictly applied. There is another aspect which I'd like to add, and which is probably not worked out the way it was intended, which is the tribunalization of justice. So, one of the features that we have seen over the last few decades is that whenever there is a special topic which requires deep expertise, that we tribunalize, we take it out of the court system and send it to specialized tribunal. It initially started with taxation as well, which I think kind of worked well for some time. But now there are many topics which go to specialized tribunals. And it's an open question as to whether that has worked well or not, because these tribunals do not have the trappings of a court, and therefore the look feel of a court and the rigor that courts follow is absent. And not often the members are lawyers or judicially trained. So you very often have a judicial member sitting with a technical member as well, and somewhere the kind of rigor that you expect from a proper court is compromised as well. So that's one approach that the country has taken, and maybe we didn't have a choice because of the sheer volume of cases. Now, whether it is, for example, the IPC, or whether it's competition cases or appellate cases of competition, or whether we have environmental cases, securities law cases as well. So these are the principle of specialization has been dealt with by tribunalization, but it hasn't always worked the way it was intended.
Very, very interesting points there by both of you. Let's take a quick commercial break here. We'll continue this very interesting conversation on the other side.
Cyril Amarchand Mangaldas presents CNBC TV18, The Thought League Season 3, A Glorious Decade, A Century of Service. Cyril Amarchand Mangaldas presents CNBC TV18, The Thought League Season 3, A Glorious Decade, A Century of Service.
Welcome back to Cyril Amarchand Mangaldas presents CNBC TV18, The Thought League. We're in conversation with Justice D Y Chandrachud and Mr. Cyril Shroff. Gentlemen, thanks very much for waiting. Justice Chandrachud, now I'm getting into the domain of reform, right? Judicial and legal reform in that sense. Economic impact assessment. I mean, the building receiving capacity, assessing impact, I think you alluded to the latter part in a brief bit, but if you can just explain to our viewers how that is very, very important.
I'll give you a very simple case. Section 138 of the Negotiable Instruments Act, has been brought into force by Parliament. And the object was to ensure that monies of creditors are realized expeditiously when checks are dishonored. So what was essentially a civil wrong, namely the failure to pay a debt, has now been converted into a criminal offense. Now, what has happened as a result of this is that there has been an upsurge in the filing of criminal complaints under Section 138 of the Negotiable Instruments Act. The magistrates have to follow the procedure of a criminal court. They have to go through all the rigors of a normal proceeding in the criminal court, subject to certain exceptions, of course, which are laid down in the Act, which I need not go into at this stage. But what happens, therefore, is this, that if an economic and social audit of the legislation is not carried out before the law is enacted, we have a great law in place, but we don't have the infrastructure to deal with the kind of litigation which will result as a consequence of the law. And it's important that we do this economic audit going forward, because that's the only way in which we can assess, when I say we, that Parliament and the state legislatures can assess whether the judiciary is actually future ready to handle these kind of laws which are now being enacted and which are the need of the hour in the area of economic regulatory governance.
Let's move on to another topic now, and this is the use of technology to make justice more available, accessible. And Justice Chandrachud, you kind of spearheaded this during your time as the Chief Justice. where are we in that process? There are still significant gaps. I mean, I think there are, again, institutional gaps in terms of funding. It is uneven application of technology, how much of it is available in what parts of the country. Take us through the situation as it stands right now.
Well, I must tell you that there's no dearth of funding insofar as technology is concerned. I was chairing the E-Committee of the Supreme Court since 2019. And my experience was this, that the progress which we have achieved in India is perhaps unheralded in any part of the world, including developed countries. I'll just give you some examples. We introduced live streaming of court proceedings so that any citizen staying in any remote part of the country can access what is happening in their case, whether it's before the High Court or before the Supreme Court. We've introduced digitization of case files, as a result of which the reliance on paper has been completely done away with. We have a comprehensive national judicial data grid, which is a repository of all cases decided and pending in the Indian judicial system. So at a glance, we have information management which is available across the board. These are just some of the initiatives. In the Supreme Court, we adopted some other initiatives like live transcription of proceedings. I ran a completely virtual court, a paperless court, not just a virtual court, but a paperless court. The idea really of this is that justice is a service. When we were operating in colonial times prior to independence, justice was regarded as a sovereign function. And a very distinguished writer on the subject, Professor Richard Susskind, says that justice is, in that sense, a service. And the way we have really adapted technology in India, including by the use of artificial intelligence, is that we as courts must reach out to citizens. So all in all, actually, there's been no dearth of funds. I must tell you that. Phase 3 of the e-courts project, which was approved last year by the government of India, sanctioned a budget outlay of 7,000 crores without a rupee of cut in the proposed budget. We had a joint parliamentary committee meeting which came to the Supreme Court, engaged with us, came up with their report, and as a result of that, funds have been made available. I think when you make a good project and a good proposal to government, I don't see why government will not approve the project. And technology is one area where we've really been able to achieve, a great deal of progress in India. And we must be, conscious of the fact that the conditions across India are not similar. You have hilly states, you have the northeastern states, you have states which are in the extreme north. But notwithstanding these difficult geographical conditions, we've been able to provide connectivity. Of course, it's work in progress. And technology is something which is always ahead of the decision maker. And it's important that we keep abreast of technology by engaging the best minds, including from the private sector, to tell us what we have to do as public institutions to make our processes more efficient and manageable.
I mean, fascinating details. I didn't know a lot of it. Justice Chandrachud. Mr. Shroff, come in here. You heard Justice Chandrachud on technology and how it's being used in courts. On the other side, as one of the top lawyers, what is your take in terms of courts adopting more and more technology? And of course, AI now as well.
So technology is going to be a game changer. It already is. Not only in terms of just regular legal work, but also in access to justice as well. And there are many parts to it. I think there is a whole routine set of litigations. For example, the 138 cases or traffic offenses and other. A lot of it could be decided by AI itself with minimal intervention of human judgments or human beings as well. So, and I think that will raise some fundamental conceptual issues as to whether everybody has a right to a human judgment. But I think that the debate is developing really in two streams. One is that for in cases, it's fine to have a much higher proportion of technology, and the human element can be kept to a bare minimum. But that's not necessarily true of other more complicated cases where we are still to see how AI can play a role. But if you were to fast forward into several decades from now, or even a decade from now, I think we're going to start seeing changes where the AI is going to become so good that the human portion, the human judgment portion, will keep shrinking. It will never go away, because in those type of cases you need human judgment as well, because human beings bring empathy, they bring intuition, they bring a more nuanced ethical approach towards how to deliver justice as well. So I actually think that AI is going to be a very important tool in terms of how justice is delivered, and technology is going to add a lot. There are many similar functions where there are sovereign functions where there could be delays, and we've seen the addition of technology change the game. For example, passports. Issuing a passport is a sovereign function. But if you separate it into an administrative function and a sovereign function, we've seen the impact that technology has in terms of dramatically simplifying the administration. You can get your passport in 2 days now, which is only because of how technology has happened. Take the same analogy on a lot of cases that are pending. You can see if you split it up into administrative and judicial, you will see dramatic results. I think AI is going to help dramatically reduce the backlog once we get it properly right.
Absolutely. Justice Chandrachud, on a lighter note, AI judge soon? How soon?
Actually, I'll tell you one thing. You can apply AI in the administrative functioning of courts, because the ability of AI to read is so much faster. Even in the process of the AI judge, as you said, judges have to read volumes of data and volumes of evidence. Now, AI can sort of organize that data for you, organize that evidence, and present it to the judge, which is not to say that the judge is not going to take the decision. AI will not take the decision. Or say motor accidents cases, where the decision is based on fairly well-settled mathematical principles. AI can at least create options for parties to settle, the insurance company and the claimants. But AI judge, to a certain extent, yes, but not completely. No human robots.
Not yet, at least. Well, I think that brings us to an end of a very inspiring start to this program, to this series. I could go on, so many more topics to discuss. But this is, of course, the CNBC-TV18 Thought League Season 3, where ideas turn into action and insights shape the future. A very heartfelt thank you to Honorable Justice D Y Chandrachud and Cyril Shroff for their perspective on the judiciary's role in powering India's economic growth, setting the tone for a season focused on leadership, innovation and transformation. The Thought League will continue to bring you powerful conversations with changemakers across law, policy, business and society. Until next time, stay curious, stay informed, and most importantly, stay ahead of the curve.
Cyril Amarchand Mangaldas presents CNBC-TV18, The Thought League Season 3, A Glorious Decade, A Century of Service.